Welcome to EUPrivacyForAll Session42 on GDPR, Representatives of Controllers not established in the Union. European Parliament suggested several amendments to Article 25, notably the absence of obligation to designate a representative concerning personal data processing related to less than 5,000 data subjects during a consecutive period of 12 months, and not related to data being qualified as special category of data or related to location, children, or employees. It would also be an exception to the obligation to designate in case of occasional offering of goods or services. EU Council, on its side, drafted a paragraph 1 requiring that the designation would be in writing. Exception to this obligation would be based on the fact that the processing would be occasional and unlikely to result in a risk for the rights and freedoms of individuals. It also stressed in an additional paragraph 3a that the representative shall be mandated by the controller to be addressed in addition to or instead of the controller by, in particular, supervisory authorities and data subjects. The final draft of Article 25 lays down that the offering of goods or services or the monitoring of individuals in EU would be the basis for the obligation to designate in writing a representative in the Union. The obligation would not apply in one case, that is to say, when the processing is occasional and does not include on a large scale processing of special categories of data, sensitive or criminal convictions or offences, and is unlikely to result in a risk for the rights and freedoms of individuals. The representative will be established in one of those member states in which the offering of goods or services or the behavior of people is monitored. The representative mandated by the controller or the processor shall be addressed to, in particular, by supervisory authorities and data subjects. Finally, the designation of a representative will be without prejudice to legal actions initiated against the controller or the processor. A key provision in GDPR is Recital 63. It basically reminds all the key points stressed in Article 25, plus in the end an additional one. The designated representative should be subjected to enforcement actions in case of non-compliance by the controller. Additional provisions such as the definition of the representative, Article 14 on the information of the data subject, Article 28 on the records of processing activities, Article 29 on the representative of the controller or the processor obligation to cooperate with supervisory authorities, and Article 53(1) on supervisory authorities' investigative powers complete the full picture. Currently, the directive lays down in Article 4 that in case of a controller being framed by the directive because of the processing of personal data making use of equipment, automated or otherwise, situated on the territory of the member state, the controller must designate a representative that would be established in the territory of that member state without prejudice to legal actions which could be initiated against the controller himself. What should accountable data controllers and processors get prepared for? First, when not established in EU, but offering goods or services or monitoring the behavior of EU citizens, controllers and processors shall designate a representative in the EU in writing. Such obligation would disappear when the processing is occasional. It does not include on a large scale processing of special categories of data or criminal convictions and offences, and is unlikely to result in a risk for the rights and freedoms of individuals. The representative designated shall be established in one of the countries targeted by the offering of goods or services or the monitoring of behavior. The representative shall be mandated by the controller to be addressed by supervisory authorities and data subjects. The designation of a representative will be without any kind of prejudice to legal actions taken against the controller or the processor. Finally, controllers and processors will have to share information on this representative to data subjects first and in the frame of records of processing activities. Last caveat, the designated representative will be subject to enforcement actions in case of non-compliance by the controller. So the question we might have in mind now is knowing more about the limits of the obligation to designate a representative.